Our first panel concerns originalism and the dead hand. Why should the thoughts and philosophies of those that have gone before us be considered authoritative in present day life? Good question. We're fortunate to have a panel of great distinction to explore that with us today. Professor Daniel Farber, Henry J. Fletcher Professor of Law at the University of Minnesota, Professor John McGinnis of the Cardozo Law Faculty, Professor Lawrence Sager of the New York University Law Faculty, and Professor Michael Moore, Leon Meltzer Professor at the University of Pennsylvania Law Faculty. Each of our speakers will have 15 minutes to proceed. Gentlemen, I will wield a mean gavel, and you may take your pick between the podium or speaking from your place. And as I understand it, the mics are live and you're wired for sound.
In his opening remarks, Steve said that we were beginning with the most abstract and philosophical topic. I plan to discuss that topic in a way that you may find disappointingly concrete and down to earth. My general view is that, to begin with a sort of heroically mixed metaphor, the dead hand is something of a red herring. Holmes once said, or said something along the lines of, continuity with the past is a necessity, not a desirability, that in fact it's unavoidable. And in reality, it seems to me that as we look around us, the dead hand is essentially everywhere. That our lives are ruled in part by the decisions made in the past, often by people who are now long dead, in a variety of ways, many of them quite humble, and in fact, many of which escape our notice, which I think is an indication of just how deeply the dead hand extends into our lives. One very small example, one that may seem almost too trivial to be worth mentioning, but the very notes which all of us are bringing to the podium are written more or less in contemporary English spelling, which is the creation of Victorian schoolmasters, now long dead, making decisions for reasons which would make relatively little sense to us today, and in some cases were simply mistaken. They had some ideas about Latin etymology that were wrong, and conform the spelling to those ideas. And yet, our most routine act of reading, we are immediately drawn into the structure that was created at that time. This is not, however, the same as originalism. I think this is the inevitable dead hand as opposed to whatever additional embrace of the dead hand is contemplated by originalism. And I'd like to talk about that kind of issue a little bit in the context of another relatively mundane example, that of law school architecture. And I wanted to emphasize from the beginning that it was law school architecture. I don't want anyone to think that I have any pretensions to a deep understanding of the history of architecture or its theory, but I have given some thought in the law school context to the effects that architecture has on the life of an institution, and indeed to the extent to which the underlying rules of academic life in an institution to some extent are dictated by the secret rulers of academia, the architects. People who are usually distinguished by having little or no understanding or knowledge of academic life, I might add. And I think this is not a bad analogy because the Constitution is often compared to the architecture of the government, the structure of government, in a way that I think at least might justify a little bit of thought. Now, how does architecture, even in the humble surroundings of a law school, affect the ongoing life of the institution? This is something I've been increasingly struck by the longer I've been in teaching and the longer I've done administrative things. And as with the Constitution, there are really two forms of influence by architecture. The first, and the one that the Constitution is most generally thought to play, is the role of architecture as constraint. Things you can't do because of the way the building is designed, things that you can't do in the Constitution because of the way the structure of government is defined. It is remarkable the extent to which, in the law school setting, important decisions about curriculum and other matters are dictated by seemingly trivial decisions made in the past about room sizes, restrooms, elevators, etc. For example, I know of several law schools that have, for various reasons, seriously considered expanding their student bodies and have found that the major barrier is the design of the classrooms in the building. Those classrooms, in fact, being designed to require sections of a certain size and therefore a first-year class of a certain size. And what's rather interesting, at least in several of these cases, is that this was quite deliberate. This is not an architectural accident. This was a deliberate constitutional act. The faculty members who were in charge of building design felt strongly against expansion, saw that there might be some temptation to expand in the future, and sought to prevent it through their structuring of the building. Similarly, those who would like to teach first-year classes in larger groups or smaller groups, et cetera, those who would like to have more clinics or fewer clinics, whatever, often find that it is the classrooms and building design that ultimately make it either possible or impossible to go ahead. So that's the architect or constitutional drafter as source of constraint. Now, there's another very important effect, which as lawyers we don't focus on as much, but which in many ways, again, represents a kind of dead hand effect, and that is the cultural effect of the architecture or the cultural effect of the Constitution. And one can see this again in a very humble way in the law school world. For example, one of the things I've been struck by is the extent to which the decisions that some architect or building committee made about office arrangements exercises decades later a profound effect on the intellectual culture of the school. Three examples, schools I won't identify. But in one school, the faculty offices are all integrated into the intellectual heart of the building, the library, of which they are an integral part. And this is a school that in fact turns out to be famous for its intense atmosphere of intellectual collegiality. Another building, the faculty offices are scattered around the perimeter of the building. It often requires an extensive trip around the building to go visit another faculty member. The faculty lounge is located outside of the office building, and for that reason has typically not received much use. And this is a law school whose culture traditionally has been relatively non-collegial, not anti-collegial, but one where in fact people tend to be, at least over extended periods of time in the institution, rather remote from each other and not very heavily involved. The third law school, which I also will leave unidentified, the faculty have been scattered in separate buildings, not even connected with each other, and with no neutral ground in common in which to meet. And as it happens, in that law school, the faculty has become an armed camp, or a series of armed camps, and the intellectual atmosphere is or at least is reputed to be hostile rather than merely distant. Now, I think much the same is true of the Constitution as well. That is, the structure of government, the ideas about separation of power, about individual rights that were initially set in motion in 1789 continue to have a profound effect about the way members of government relate to each other, how they think of their positions, how outsiders such as scholars think about these matters, and so forth. So far, at least, I hope I've defended this as a homely and perhaps trivial, but nevertheless potentially plausible analogy. Now, the question is, given that there are these very strong dead hand effects around us, what does this have to do with original intent? And it seems to me the answer is not very much at all. That is, one can fully acknowledge these inevitable forms of the dead hand without in any way embracing originalism. This came to my attention a few months ago when we were considering at Minnesota revamping the administrative offices, which are on the second floor of the law school. We wanted to change the way students were moved through these offices and what the traffic flow was and so forth. You can hardly get more mundane than that. In the course of this discussion, one senior faculty member said, "You can't do that. The architect intended the students to come up the main staircase and then turn into the offices, and this isn't what the architect intended." And everyone else in the room stared at each other. Why would we care what he thought? What debt did we owe this architect? It is true that in many ways, we literally live in the structure created by that architect. In the many ways that I've talked about, it affects our lives. But to the extent that the architect's intentions are distinct from or given any separate consideration from the actual building itself, it's very difficult to see why we should care about them. Perhaps if it had been Frank Lloyd Wright and somebody whose views we would just care about because of our great deference to him personally, that might have been different, but although this guy is said to be a pretty good architect, he's not Frank Lloyd Wright. And basically, nobody could see why that should be controlling. So I think this dead hand is one thing, but the question of original intent really has, at best, no connection with the inevitable ways that the dead hand enters our lives. Now, let me say two things quickly about this analogy. One response an originalist might make, it seems to me, is that the question that was raised was about the intent of the architect. Many originalists prefer to talk about the original understanding or about the views of the average informed reader or something of the time or something like that. I don't think that helps in this case. That is, it would have been at least as bizarre for somebody to say, at the time this building was designed, the reasonable architect examining the blueprints would have understood the traffic flow to be up the stairs and then to the right. If there's any reason to care about the architect's intentions, there is surely less reason to care about a bunch of other people's understanding of the building plan. A second argument is, well, buildings are different. They exercise their influence through their physical presence. Constitutions are texts which must be interpreted, and therefore the constraint of the text can only take place through the original intent. And that's a topic that could obviously take a great deal of time, but it seems to me to be quite a non sequitur to say that interpretation is involved and therefore, of necessity, the original intent must be the source of constraint rather than other factors. In many cases, I think the Constitution has its most profound effects where it is least interpreted. The simplest of the constitutional rules, like 2 senators per state, may have far more to say about our form of government than all of the Supreme Court decisions ever written about the Due Process Clause. Well, I am at risk of having Dan Polsby throw me bodily off the stage, so I think I will bring this to a close and turn it over to the next panelist. Thank you.
The question of why we should be bound by the original Constitution is often framed as why we should be guided by the dead hand of the past. The notion that a document should be viewed as an unfortunate constraint on the present because it was created in the past carries with it an implicit premise about man and history that I would like to challenge. If man makes his own history constrained only by the culture we inherit, whether we should submit to that inherited culture and the documents it generated might seem plausibly, perhaps, to be an open question, to be decided in each generation. But there's a different view of history, one shared by the framers, and again, I think today growing in acceptance. It is that man has a permanent nature, and this nature substantially constrains the human history man can create in general, and the outputs that can be expected from government. David Hume put it well. There's great uniformity in the actions of men in all nations and ages, and that human nature remains the same in its principles and operations. I think accepting this latter, Humean view, would put the issue of the Constitution's relation to the present in a completely different perspective. If the principles and structure of the Constitution are premised on a correct view of an essentially immutable human nature and the relation of that human nature to collective governance, the original document should not be regarded as a dead hand, but as a living source of guidance. Thus, today I hope to sketch two propositions in a somewhat unqualified manner. The first proposition is that the Constitution of 1789, the Bill of Rights, was largely generated by a view of human nature. And second, that this view of human nature was in the main correct, in that it accords with the model of man's nature that is generated by modern evolutionary biology. As Democritus hit on the atomic theory 2,000 years before the mechanisms of that theory were confirmed, the framers, along with the help of David Hume and Adam Smith, developed a theory of the psychology of man and the distribution of his talents 200 years before modern evolutionary biology largely confirmed that theory. I'm not saying the framers' theory was perfect, just good enough for government work. The framers had the view of man, in Richard Hofstadter's words, as an atom of self-interest. Indeed, their whole new science of politics was premised on this view of human psychology. Government could not be dependent on man's benevolence or his virtue. On the other hand, they didn't believe that man's self-interest meant that he was depraved or that progress in civilization was impossible. To the contrary, they agreed with Adam Smith that in the private sphere, this self-interest could lead to the welfare of society as men would profit by exchanging what they produced through trade. The spirit of commerce would in turn create a union among the people, a union forged by enterprise. The Constitution therefore tried to prevent the individual states from interfering with trade and authorized the Commerce Clause to dismantle trade barriers. For the same reason, the framers gave substantial protection to property enterprise through such provisions as the Contracts Clause and the Takings Clause. The framers also understood that the same self-interest that contributed to, in the private sphere to social welfare, both in material well-being and the union among people, made man a knave in the public sphere. It was that same interest that led men to form factions to try to expropriate the wealth of others through government. In the Federalist, indeed, Hamilton has a very sophisticated explanation, one that we'll see accords also with modern biology, for why man's self-interest leads to good behavior in the private sphere, but bad behavior in the public sphere, where men act in factions to get what they want. Regard to reputation, Hamilton noted, has a less active influence when the infamy of a bad action is to be divided among a number than when it is to fall singly upon one. A spirit of faction will often hurry into improprieties and excesses its members, which they would blush if they had performed in a private capacity. In other words, in private dealings, individuals can monitor the action of others, and thus everyone has an incentive to maintain a good reputation so that others will deal with him. Because it is more difficult to monitor people acting in large groups, we are much more likely to seize all we can through political enterprises at the expense of others. Just as the part of Constitution was structured to facilitate gains from trade that could result from the operation of self-interest in the private sphere, much of the rest was designed to restrain the bad effects of the operation of self-interest in the public sphere. This is familiar territory. Federalism meant regulatory competition. which limited the ability of government regimes to impose oppressions on people. People can always leave. The separation of powers and bicameralism raised the cost of factions, of getting control of the entire government. And different branches acquired different institutional interests, thus ensuring a perpetual struggle and a kind of stated nature at the heart of Leviathan. But besides the self-interested nature of man and its very different effects in the private and public spheres, one other fact about the nature of man dominated the framers' inquiry. Men were substantially unequal in abilities, and intractably and naturally so. Indeed, Federalist 10 turns on this fact about human nature. Men have unequal faculties for acquiring property. Note that Madison does not simply say that men possess property in unequal amounts as some contingent culture or fact about a particular society. Their faculties themselves are different and unequal. The brute fact of inequality becomes yet another reason for finding mechanisms to restrain expropriation through government. The framers understood that natural inequality exacerbates the danger of factions. It means that there will be a number of the less talented at acquiring property who will be a ready reserve of political actors able to be persuaded to expropriate the property of the more talented, thus threatening gains from trade. And there will be no shortage of persuaders, because the framers well understood that there always would be ambitious people who would seek their status not from trade, but from getting control of the government. Thus, the Constitution tries to create a large republic where a large number of factions would lead to shifting coalitions that would have difficulty in maintaining entrenched control of the government. National democracy, therefore, is an instrument for protecting the different faculties of men, and it stems directly from the framers' understanding of the brute fact of inequality. Of course, this Constitution that was generated by the framers' notion of human nature has largely disappeared in the last 50 years. The protections for property have vanished. With the demise of any restraints on Congress's power under the Commerce Clause, federalism has passed away. With the rise of the administrative state, the separation of powers is a shadow of its former self. These are now the familiar stories of the triumph of the New Deal and afterward. What is less familiar, I think, is that these revolutions coincided and were substantially caused by a changing view of human nature. Indeed, not only do many advanced modern thinkers not disagree with the framers about what the nature of man is, they disagree that he has a human nature in the sense of a permanent and essential truths about human behavior that follow from just the nature of his being. This sense of malleability, in my view, has contributed greatly to the rise of social democracy and social engineering, which contributed greatly to the diminution of many of the provisions of the Constitution of 1789, the Bill of Rights. While most of this century social science has ignored biology and viewed social practices as wholly culturally created, there is now a revolution going on in the social sciences. For the last 2 decades, scientists in psychology, economics, anthropology, and linguistics have been beginning to understand that social practices are not simply rooted in conventions, but in our evolutionary heritage. Social practices spring from the complex computational architecture of the human mind that has been shaped by millions of years of natural selection. The rise of Darwinism in the social sciences is vindicating the framers' view of human nature in 3 essential respects. Man is by nature self-interested, which substantially limits the possibility of wholly altruistic behavior to unrelated individuals. On the other hand, that self-interest is consistent with the possibility of gains from trade because man has a highly developed, evolved sense of reciprocal altruism on which the concept of exchange can be built. Finally, individuals have substantially natural, and at least on the present basis of human knowledge, intractable inequalities that make politics of redistribution inherently very costly. Let us take each of these 3 propositions in turn. Man is self-interested because he is a biological organism. As a matter of evolutionary theory, organisms are precisely those things that act as if their welfare were more important than that of all other organisms, except when other organisms can spread their distinctive genes. Because of the way we reproduce, there are relatively few other people closely related to us, and thus as a matter of evolution, our core interests have been circumscribed to ourselves and relatives and mates. We are not like ants, who, because they are closely and equally related to all members of the colony, submerge their own interests in the interest of some large collectivity. This fact has large political implications. In any society large or heterogeneous enough for members to sense that they are unrelated, it suggests that members will seek to turn common resources to their own advantage. It is because in evolutionary time, wealth and status is highly correlated with reproductive success. Rent-seeking, thus, in the democratic welfare state is hardwired in man. Nor we should be surprised that in more strongly collectivist states, such as communism, that individuals spend much of their time using the state apparatus to become more equal than others. There is simply a mismatch between collectivism on any large scale and our evolved nature. As the world's foremost expert on ants remarked about Marxism, wonderful theory, wrong species. But the framers were also right to believe that self-interest, that is the bane of collective processes, can be the engine of beneficial private enterprise. Indeed, an evolutionary view of man gives us new reasons to believe that trade goes with the grain of humanity. Man's self-interest is tempered by reciprocal altruism, an evolved willingness to perform useful acts in the expectation that the person on the receiving end will reciprocate. The bundles of qualities that make us reciprocal altruists was very useful in overcoming the pervasive prisoner's dilemmas of social life, facilitating, i.e., non-zero-sum exchanges in the long part of human history where enforcement of obligations were quite imperfect. In those societies, individuals gain resources over non-reciprocal altruists through these exchanges and over other species without such a strongly evolved sense of reciprocal altruism. Indeed, the new science of evolutionary psychology suggests that much of our emotional life, gratitude, sympathy, moral outrage, have evolved to regulate the relations of reciprocal altruism. Cognitively, too, as well as emotionally, we keep a mental account of what other individuals have done for us and against us, a fact immortalized, I think, best in Tom Wolfe's discussion of a favor bank in Bonfire of the Vanities. I don't want to sound Panglossius about reciprocal altruism. Humans, like all other species, have strong interest in deceiving others to their own advantage if they can get away with it. But the innate tendency to reciprocal altruism gives us a strong foundation on which to erect institutions to enforce obligations that serve mutual self-interest. Contract and commerce are not simply social artifacts or some sort of pre-political regime. They are rather ingrained aspects of human nature, and the framers were therefore wise to construct a republic that tried to encourage trade and perfect the protection of property rights, a kind of right of which man had an intuitive understanding of. It is clear also that Hamilton was right essentially about why self-interest operated so badly in politics. We have simply not evolved the ability to monitor the gains and losses from large-scale political actions. Since we cannot easily engage in the relations of reciprocal altruism in politics on a large scale, we revert to a narrower self-interest in the public sphere. Finally, modern science also confirms Madison's view that individuals have unequal abilities for acquiring property. Since resource acquisition ability was important to genetic fitness of our ancestors, traits that contribute to that ability were selected for over time. Evolution proceeds by variation. It proceeds by inequality, and thus as a matter of theory, it is impossible to deny that there will be human variation in such important traits. The theory is also confirmed by recent studies that suggest that intelligence and other measurable personality traits are correlated with income and social status and are in important measure inherited rather than simply shaped by the environment. It is only recently that the fruits of the Darwinian revolution are becoming widely available to the public, but it is seeping out, and I think it does account in part for recent events in Washington. The political branches are engaged in a revolution of sorts, which is what gives us now the sense of politics as a tape played backwards. Now, the Great Society and the New Deal, which in my view were based on a very different view of human nature, indeed the Great Society, I think, on a view that man did not have any nature given to him, are passing away before our eyes as a more limited government is established. The return of human nature is the return of limited government. The court has not yet really become a part of this counter-revolution, but as the return of human nature continues, we can expect it to join in. In that case, the Constitution, far from being a dead hand, will be a living hand, beckoning us back to a kind of government that comports with our nature. In fact, it turns out that a living Constitution is the original Constitution, because that Constitution is founded on a correct understanding of the living organism, namely man, that generates our politics.
Now for a somewhat different view. I was at a linguistics conference here a few days ago, so until I went to this conference with Bob Bennett, amongst others, maybe it's Bob's fault, I wasn't sure after the conference what the title of this panel was supposed to be about, Originalism and the Dead Hand. Because one of the things linguists do to you is destroy the sense of ordinary expressions by revealing hidden ambiguities. So fortunately, Steve Calabrese got rid of a couple that had occurred to me after the conference, that this was actually going to be a conference revealing the unknown plagiarisms of the late Judge Hand, for example, or that this was going to be a conference of the continued creativity of artists after paralysis of their upper extremities. I was trying to work out architecture. It did seem to me it was perhaps a third reading. Anyway, let me say a bit then about the question as I understand it, given all these ambiguities. The question is about the role of the past, the tradition, indeed the dead hand. It was Dickens who asked us why it was, with regard to the courts of England and the common law, that dead men sat on our benches. What is the authority of those who preceded us, indeed, to dictate the ideals by which the present generation lives, and particularly those basic ideals we call a constitution? That strikes me as a quite real question. Now, it also has occurred to me, having raised this sort of question before, that there is a tendency to want to refuse to answer it. That is, to refuse the question as a question. I was most struck by this when I was teaching a seminar for judges in California. I and a good friend of mine for years ran seminars twice a year for the California Judiciary when we were both teaching at Berkeley, Jeremy Waldron. Jeremy raised, it was his session, we had an hour and a half. Jeremy raised for the judges the question of the authority of the past, and specifically the authority of our constitutional past for them as judges. And one justice of the California Supreme Court drew himself up and said, I don't believe that there's a person present in this room that would question the authority of our Constitution. And since everyone else in the room was going to defer to this particular justice, that left Jeremy and I staring at each other with an hour 29 to go and nothing to talk about. But unlike that justice, it does seem to me, every judge and every theorist who would make normative recommendations to judges, which is the enterprise in which a lot of us are engaged, has an obligation to ask and answer the question about what are those texts that bind judges as judges, what are those texts that bind any legal actor, be they a judge or a citizen or a lawyer, in his or her role as a legal actor. Now, sometimes there are enterprises that don't require that you answer those kinds of questions. The one that comes to mind is actually H.L.A. Hart's enterprise in the concept of law, because Hart famously argued that judges don't have to answer the question, what is the justice of the rule of recognition? Remember, that's his term for that secondary rule that licenses all other rules as law, i.e. a constitution. He said judges don't have to answer the question about the justness of the rule of recognition in order for there to be a legal system. They only have to accept it, by which he meant they only have to have an internal attitude towards it for whatever reason, including just dumb, unanswered, and unasked for habits. Now for Hart, since he was doing descriptive questions about when you have law, that's a possible answer. Joe Raz and I had criticized him for years. The last letter I got back from Hart a year before he died maintained the position he always maintained, which was, descriptively, judges, for him, did not have to answer the question about things like the authority of the Constitution or the intellectual tradition that informed it, because you still had a legal system. But that, of course, was a descriptive enterprise, and I think it's a plausible answer for Hart within that enterprise. But if you're engaged as a judge or as someone who recommends to judges how to decide, if you're engaged in the normative enterprise of saying, what are the standards that can justify the use of state coercion on unwilling citizens, if that's the game you're playing, now you have to ask and answer the normative question that Hart's jurisprudence refused. Why is the rule of recognition, if it's to be accepted, justified as one that we should accept? What good reasons stand behind it? That question, I think, has also been refused by otherwise pretty competent constitutional theorists. I'm thinking of a well-known article by Henry Monahan where he says it's axiomatic within constitutional law that the document and the original understanding behind it is authoritative. He says it's our unquestioned first principle, however much political theorists might want to question it. Now, if that is anything other than you put your pants legs on one at a time sort of rationale, namely you ask questions of justification first and then you apply it later on, you separate your theory of authority for the Constitution from your theory of its interpretation, although you need both. If it's anything other than that, then it strikes me it's an invitation to irrationalism. But you need to ask yourself that question about the past that Dickens was so complaining about. So let me ask it and give 5 brief answers, most of which I find problematic. First answer is this one. It's a question, as the paraphrase from Holmes a moment ago would suggest, that ultimately has a necessary answer. That is, it's not just that it's desirable to look to the past, it's actually necessary because, and here going beyond Holmes, each of us stands in the tradition that comes from that past. This is a possibility argument. The argument is you can't stand outside the past. You can't stand outside the tradition that comes from the past because you have no place from which to make such judgments. 2 sorts of contemporary examples, neither of them that should be particularly amenable to this audience. One from what a colleague of mine rather unneutrally described as post this and that, critical this and that, philosobabble, namely postmodernist movements, postmodernist hermeneutics, which argues you can't stand outside of a tradition. In order to judge the tradition, that would be to ask a meaningless external question. If you want something a little closer to home, Ronald Dworkin's Law's Empire, the interpretive jurisprudence that he expounds, is an argument that you can't stand outside your concepts, which after all define, as he puts it, the plateau of agreement that makes disagreement possible. And in the book defends a concept of law that says necessarily you look to the past because that's what our concept of law, however much you dispute its conceptions, has to be about. Now, I think those alleged conceptual necessities run contrary to everyone's actual experience in doing either moral or political theory. None of us are hostage to the traditions in the way that either Dworkin or his hermeneutic friends to the left would suggest. Each of us has not only a birthright but an obligation to make judgments about what it is the past has bequeathed to us to see whether or not it should be continued, and that's not impossible. It may be impossible to stand outside all traditions whatsoever, but that's not to say it's impossible to stand outside any particular tradition in the name of some other, perhaps one that you yourself are inventing. We all sense, I think, that possibility of what I would call revolutionary moral judgments, judgments that go against our own culture, the one we've been raised in to say, they've got it radically wrong. It's thus not an unraisable question, psychologically or epistemologically either. So let me turn to 4 other arguments. In this audience, since 3 of them come as interpretations of Edmund Burke, maybe you'll find them more agreeable. First interpretation of Burke is what I think of as the epistemic interpretation. It's the modesty of individual human reason in face of the collective wisdom that's bequeathed to us by the past, an almost Darwinian view about the survival of the fittest of social ideas if they're given the test of time in which to flourish or to die. That's an epistemic point of view because I think Burke said 2 sorts of things. 1, each individual has a rather puny share of reason. Actually, he subdivides that in a variety of ways. Most people, although not all, he thinks aren't very reasonable anyway. Perhaps all of us are more passionate or prejudiced, as he put it, than use our reason, and indeed prejudice often gets us better results if it continues our tradition. And he thought, looking particularly at the abstract philosophy leading to the French Revolution, nobody, whether one of the intellectual elite or one of the common masses, nobody, whatever his or her intellect, can make judgments about general rights such as the rights to liberty, equality, and fraternity in the abstract. If you're trying to figure out what liberty is, he thought you had to do it in context, i.e. in the particular circumstances of the tradition which you yourself knew. On the other hand, he thought, people who individually couldn't make very good decisions, collectively over time made significantly better ones. They got closer to the truth, say, about liberty by not trying to overthrow the wisdom of the past, by in fact making their own radical judgments that were different than those in the past. That's epistemic because it has to do with which is the best way to come to a judgment that's most likely true. Defer to the tradition you're a part of, or step away from the tradition and try to judge whether or not it's got it right or wrong. Now, there's a number of answers, I think, to Burke. One of them is that our tradition, in which I include myself, our tradition is much more Lockean than it is Burkean. It seems to me when we declare certain truths to be self-evident, we're simply echoing the Locke lectures, the original ones. There's lots of them now in England. The Locke lectures at Oxford in the 1660s, where Locke said, you can know the truths of morality with both the certainty and the ease with which you can know truths about mathematics. That is, we as individuals can know it, not that we collectively have to defer to others. So if one wants to talk about our traditions of knowledge, at least the tradition that descended to us from Locke through Hamilton, Madison, who read Locke as much as Hume, that tradition is one in which individual reason is not so puny. Second point, isn't Locke better than Burke on this? Isn't it in fact the case that we each have a sense that sometimes, at least, our own judgments to be preferred from that which we got as an intellectual inheritance? John Ely makes this point nicely in his book when he gives us our example of tradition, the Sunset Laws, which were in force when I grew up in Oregon in the 1950s, in which all black people had to be out of town by sunset. He said that's one of our traditions, but it was a wrong tradition, and individual reason certainly can stand against it, no matter how revolutionary it might seem. Isn't the other side also suspect to many of us when we hear John Mansfield's famous statement about the common law working itself pure? Doesn't that cause most of us to smile in the sense that the idea that the accidents of history should in fact lead to a better and better common law, it might be true, or it might equally lead to the kinds of traditions that are pernicious. It depends on who you get on the bench, or who it is that are the mainstays of any tradition. Second argument's epistemic argument, first interpretation of Burke. Third argument, second interpretation of Burke, is the religious one. Very quickly, I do think Burke thought that traditions were in part sanctified by God not changing them, was a theist. Sort of like the old argument about the common law, if Congress doesn't change it, then presumably Congress has sanctioned it. Same argument for God vis-a-vis traditions. Actually, that was my first theory of the Constitution in the 5th grade. My teacher told me that the drafters of the Constitution were all divinely inspired. I'm a 5th grader, I sort of wrote that down. I'm not a theist anymore, so I can't buy that one. Even if you were a theist, notice you might be more like Thomas Aquinas. You might think God doesn't care very much about institutional detail. Aquinas' example was the law of deposits in 13th century France. God just doesn't speak to that issue. Human law has to work it out. That's why he introduced the distinctions between determinations that humans work out from deductions from the first precepts of the natural law. I would suspect Aquinas would say the same about a bicameral or a unicameral legislature. God probably doesn't care very much one way or the other. Leaving aside then theism, the main argument in Burke, I think, is an argument of prudence, which is the fourth of my arguments I want to talk about, the third Burkean construal. The argument of prudence is to the effect that not only is human individual reason frail, but if it fails to maintain order, then the disasters are both unpredictable, but at least potentially quite large. Of all odd bedfellows, that makes Burke sound an awful lot like John Rawls in A Theory of Justice, where he advocates the conservative maxim-in strategy in the original position under which we choose constitutions. Namely, if you can't gauge probabilities accurately, you're in a comfortable enough position that the upside potential is not that great, but the downside risks are unacceptable if they materialize, it's rational, Rawls would agree with Burke, to in fact not gamble. And that's an argument of prudence, saying if we've got a tradition that roughly keeps the peace, don't rock the boat too much. That's actually a pretty good argument. However, remember what it established. It was only an argument of degree for Burke, as it is, I think, for us. It's an argument of degree because, remember, it didn't justify using tradition to nullify incremental change, only revolutionary change. And remember his example of an incremental change? The American Revolution was an incremental change because it appealed to the tradition of Englishmen. It was the French Revolution, no doubt he would have added the Russian, which was the disruption, much to be feared. So even if you're pursuing the rational but conservative maxim-in strategy, that doesn't mean you would pick anything besides the text of our Constitution as the thing that maintains the tradition. More specifically, it doesn't mean you would pick a particular interpretive strategy called originalism as the only way to interpret the text that carries on the tradition. We can probably interpret it lots of ways and carry on the tradition. My time is just about up. Dan's been very nice to me. It's one of the benefits of having taught here before. You know, it's really hard to throw me off. So let me just raise the fifth argument very quickly. I'm not even sure this is a separate argument. It sometimes strikes me that it's mostly just the grumpiness of people as they get old, but it goes something like this. You know, remember, Socrates, amongst others, said about the youth, they're corrupting society, morals are falling apart, society is going to hell. That's roughly the grumpy version. A principled version is what Joel Feinberg calls the conservative principle, that every majority has the right to have its own traditions, not contaminated by behavior which flouts those traditions. Now, there's a little intuitive appeal to that. It's the sense that as an organic unity, a society has a right to preserve itself against change for no better reason than it doesn't want to change. It values its past. But two huge qualifiers. One, in any society, such as the Federalist Society particularly, that cares about liberty at least as much as tradition, you can't go very far down that road without making someone unduly conform and lose any liberty of any value whatsoever. The second point is this. Notice this doesn't justify giving authority to the past. Hell, Earl Warren could have used this argument to justify using, the evolving standards of decency that mark the progress of a maturing society on the explicit conservative thesis that each generation has the right to live by its own ideals and not to have other ideals from the future or the past thrust upon it. There's nothing inherently preserving of tradition in the conservative argument if it has any bite at all. Well, I have lots of other things to say, and maybe I'll get a chance on the rebuttal. I do think most people's theory of authority of the past is like John McGinnis's. They agree with the past, i.e. it's their present, and I understand that argument. It's just not an argument that gives any authority to the past.
Well, far from topping that, I need to begin with an apology in the sense that I am going to talk about originalism, and I am going to talk about the problem of the dead hand, but it's a rather special piece of originalism and a rather special objection from the dead hand that I want to address. On the other hand, I hope to get the prize for conceptual sprawl in the process of doing so, since as I sort of rethought my remarks, it seems to me I'm also offering explicitly an alternative to originalism and identifying at least one intersection between most accounts of constitutionalism and originalism. So at least what I make lose in depth, perhaps I get in breath here. I last spoke about the Constitution at Northwestern on the occasion of the Thayer Conference. And in the course of speaking at the Thayer Conference, I sketched a justice-seeking account of constitutionalism in the United States. On my account, which I labeled the justice-seeking account for what I hope will be obvious reasons, The liberty-bearing provisions of the Constitution are recognized for what I think they are, namely general principles of political justice set out at a high level of generality. And on this account, wide-bodied judicial interpretation of those provisions is at once invited and required as part of the judicial role within this notion. Now, I don't take this to be a bad thing, and emphasize that when I was last here. I think the aim of constitutionalism is to bring us closer to a realization of the conditions of political justice in the United States. And I think that the collaboration between popular constitutional decision-making, speaking as it does at a high level of generality with regard to the liberty-bearing provisions, and a rich, detailed judicial filling in of those principles, is a reasonably good set of mechanisms, pragmatically well-designed mechanisms, for bringing us closer as a society to the conditions of political justice. Now, I say all this for two reasons. The first is I've obviously identified myself as something other than an originalist at this point. But the second reason is, in an interesting way, the justice-seeking account of the Constitution that I hold to be true actually does involve a story about originalism and needs to confront a problem about the dead hand. And it's that problem of originalism, that issue of originalism and that claim from the dead hand that I want to talk about briefly this afternoon. On the account that I've offered, it's not just an accident that our Constitution ended up the way it is. That is to say, in its most important liberty-bearing provisions, speaking at a high level of general moral principle. Because on my account, it is the combination of Article 7 of the Constitution's conditions for the ratification of the Constitution and Article 5 of the Constitution's conditions for the amendment of the Constitution, which have, in my view, the important common element of making the Constitution hard to launch and hard to amend, and moreover, because of their requirement of a supermajority of state support, require a certain kind of geographical diversity. On my account, these provisions conduce to a certain stance in the drafting and amendment of the Constitution, a stance which, on the one hand, encourages general principles acceptable to a diverse population for which the states have been as good a proxy as any other within our structural system, and moreover, because of the obduracy to change that Article 5 builds into the Constitution, it means that thoughtful persons realizing they are installing provisions in their Constitution not just for themselves today, but for themselves 25 years hence, and not just for themselves, but for their children and their children's children, that such people will be driven naturally both to sound principles of justice, but more importantly, to principles of justice that speak at a high enough level of generality that it makes sense to install them in an enduring Constitution. So in my view, Article 5, or some facsimile, is a rather critical part of the Constitution. It might be seen as the Constitution's Constitution in some sense, since it derives an outcome of constitutionalism, which I think is important and attractive. Now, it turns out that it's important for me, therefore, to press the view that at least Article 5 has a kind of stable, enduring, original meaning, that it is indeed, in fact, the exclusive mechanism for amendment, and that it can't, if interpreted as the exclusive mechanism, as I think it should be driven around by democratic majorities who hold a different view of how their government should be. Now, you might think that doesn't pose a problem, because after all, there's something very different between the broad principles of justice, such as due process and equal protection, and the mechanics of the Constitution, such as referenced earlier, the provision that there be two representatives from each state in the Senate of the United States. You might say you can be original about the latter, the mechanics, without being originalist about the former. But I want to take up a special objection to originalism in the Article 5 context that I think offers a particularly poignant version of the dead hand claim. And then I hope to ultimately reject that argument. Now, let me say this is by no means the only argument that's advanced in favor of the non-exclusivity of Article 5, but it is one argument that is peculiarly apt to this conference, and I also think perhaps the strongest argument in favor of the non-exclusivity of Article 5. In essence, the argument runs like this. In a democracy, the people own the government. The government doesn't own the people. And to treat Article 5 as exclusive and enduring is to deny the capacity of a democratic people to decide that their government has become inconvenient, inappropriately shaped, and in an appropriately deliberative, reflective manner to decide as a people that it is time to change. And the straitjacket of Article 5 itself ought to be open to democratic revisiting and revision. So it is an argument very much from the dead hand in the spirit that I think precisely animates the claim about the dead hand. And it says, just as I think Article 5 may be the Constitution's constitution, it is most vulnerable to this objection because it insists that a people renounce their own democratic consensus if it doesn't assume Article 5's shape and form. Now, the answer to this argument that I want to offer turns on the following perhaps obvious problem, and that is, what do we mean by the people in this story? When we say that the people have the right to change their constitution, what do we mean by that? What fraction of the people? After what kind of deliberation? Dispersed how? What representation of the people, or more exactly, what procedure for resolving dissensus among a population will we use to represent the people to displace Article 5? Now, in this sense, it's interesting to recognize that the drafters of the Constitution had to invent a people. They were in a very peculiar situation. They had to devise the circumstances under which their Constitution would be ratified. And they couldn't turn to the people and ask for approval of their mechanism for ratification. They didn't have a people. They didn't have an answer to the question, what represents the people? So they invented a people. And they invented a people, I want to argue, on lines that are interesting and persuasive. I think Article 5 is appropriate in sound in large measure for reasons that I've already identified, namely that it conduces to the right kind of constitutional decision-making by the popular constitutional decision-maker, the popular sovereign, and that it therefore conduces to a constitutionalism that does the job that I believe it should be understood to be there for, the job of seeking justice and just outcomes. Now, another way of putting this proposition is that the claim that the people are entitled to change their government, in that claim, there's no available placeholder for the people other than Article 5. Certainly no readily available placeholder for the people other than Article 5. And when individuals talk about we the people in constitutional theory, I want to reach for my wallet and hang on to it very tight. Because at most, we the people, whether it's put in capital letters or quotations, in every instance refers to a state of social dissensus measured by a given procedure. And in the claim that the people have the capacity to displace Article 5 or any other inconvenient part of their government, there is no placeholder for the idea of people other than Article 5 itself. Now, you might respond with a very plausible objection at this point, which is the story that I've told up to now can't be completely true. It cannot be the case, conceptually, that a democratic people can tie themselves up to any given mechanism like Article 5, and then even if they discover eventually that in some way it is a grotesque error and it paralyzes them, that they have no way to release themselves from their own prior constitutional formulation. I think that objection is right. But I think the circumstances of relief have to be both substantively and procedurally extreme. That is to say, I think, to take the procedural question first, the circumstances that justify a release from Article 5 have to be widely acknowledged to exist within the society. because we don't have a fact finder other than the people, and we don't have a people. We have to turn to very broad consensus and understanding. Secondly, I think the circumstances substantively have to be extreme, and I think they are essentially the circumstances of constitutional breakdown. And I would describe the circumstances of constitutional breakdown as follows. There has to be a widespread belief that the constitutional arrangements that we have created a serious obstacle to our ongoing sound governance. Secondly, there has to be a view that Article 5 in these circumstances somehow renders or poses an insuperable barrier to the change of those constitutional arrangements. And thirdly, we have to believe that Article 5 is a badly flawed representative of the people, a claim that I do not believe under present circumstances, and think not only is there no such widespread belief, I think there should be no such widespread belief. Now you can ask, what circumstances might ever justify the view that there has been a constitutional breakdown? I'll offer two, one more plausible than the other. I think the period of Reconstruction prior to Reconstruction may have constituted a constitutional breakdown, because we had Article 5 with its requirement for a distribution of consensus among the states of a supermajority kind, and we had a whole segment of American society that had announced a whole segment of American humanity to be property rather than persons, and denied that segment the franchise. You could imagine that we were in a state of Article 5 paralysis that constituted the circumstances of breakdown. The framers, I think, may have believed that they were in the circumstance of breakdown when they ejected us from the Articles or withdrew us from the Articles of Confederation. I like to think that in part out of a charitable interpretation of their own political theory for the following reason. The framers, as has been observed by others prior to me, adopted a remarkable conceptual stance. They announced their capacity to disregard the legal circumstances for change of the Articles of Confederation and of their respective state constitutions. At the same time, they installed a constitution which announced to their successors that they could only change this document under prescribed procedures. And the question is, what could they have in mind with this Janus-faced view about the circumstances of legal change? They might have thought they were the fabulous framers. The fab framer view is of some appeal, and probably was especially to that group of gentlemen, and that we lesser mortals simply shouldn't have the prerogatives that they assume for themselves. But I'm very reluctant to attribute that conceptual view to themselves. They might have thought they were engaging in a rather clever bit of hypocrisy or smokescreen, that they were telling us we couldn't change our Constitution, but of course we really could change our Constitution. I'm not entirely comfortable with that. But someone in their position who held the view that there were limited circumstances in which one was prepared to step outside the governing law and renounce it to have broken down and launch a new government was a very different state of affairs than when one was living under an ongoing and on the whole successful constitutional regime. That's the circumstance we find ourselves in. Under those circumstances, I believe that Article 5, read as exclusive, is a legitimate instance of the dead hand, and an instance of the dead hand quite crucial to a sound understanding of a constitutionalism which is not pervasively originalist. Thank you.
That's ours. Now you get your turn. As you approach the microphone to ask questions, please make sure that it's turned on, because we have audio equipment in operation here. And not to be ruled by the dead hand, but we do have traditions of our own that run with the land. So Professor Lawson, if you have any first question to ask, it seems to me that you are entitled to do so.
This is a tradition at Federalist Society events. Reference was made to the one pants at a time theory that tries to separate out the question of what law is from what law ought to be, or in the dead hand context, what the dead hand says from why one would care what the dead hand says. And I would just like to hear some of the panelists reflect more than they have on that, because that seems to me the bottom line here. Isn't it entirely sensible to put your pants on one leg at a time, as anyone who's tried to do it otherwise could say? How can, or put another way, how is it possible, even in principle, at least in the originalism context, to ask the normative question about whether one ought to care about the dead hand, unless one first has done the descriptive job of figuring out what the dead hand tells us?
What's this problem of the left dead hand not knowing what the right dead hand is doing? It seems to me, Gary, that the question that you've asked presupposes, God, this is probably this linguistics conference again. I have two different interpretations of what you said. One is, you have to actually know the substance, sort of at the level of details, for example, that John McGinnis was going through, as to what the substantive moral political theory is that you're then inquiring as to whether or not the dead hand of the past, that specific originalist past, right, has any authority. If you go that far, then I think you fall into the trap of saying that you agree with the dead hand, you agree with the substance of the past or not, and then you never get to the question of its authority. Imagine a theist who has two different views of God. The one view is whatever God commands is good, right? God's command makes it good. Now you really want to know what God commanded, not because you're going to judge whether it's good or not. You're trying to figure out what's good just by asking what God commanded, right? As opposed to the other theist who says, well, God only commands good things. That is, what's good is determined antecedent to looking to God's command. And then, like the weatherman, you check up on him to see how he's doing with his commandings. Now, the second mode of proceeding, after you've ascertained the content, checked it out, saw whether it's any good or not, gives no authority to God. At best, he's a good weatherman. So that in one sense of your question, what you don't want to do is figure out exactly what the originalist political theory is, because it'll warp your question as to whether you're giving it, whatever it says, any authority. So I think you have to separate what it says from whether it has any authority. That's my first interpretation, but that's long enough.
I mean, to put the same point with just a little different emphasis, I think the question is whether this source of aged authority, the Constitution, is meant to function as authority or argument. If it's meant to function as argument, then of course we'd like to hear it, listen it, judge it according to the wisdom of the framers and according to modern science, and say, yes, it turns out it speaks very persuasively to us. If it's authority, it's offered to us precisely in the circumstances when we might not otherwise agree with it. The reason for agreeing with it is its capacity to bind. And that emphatically does not require prior knowledge, and indeed, we might discover that authority binds us when we disagree with it. That's what would make it authoritative over us, would be the test of authority on us.
Let me, unless you wanted to jump in. Since in some ways I most avoided the normative question in favor of the descriptive, I think in some ways the point that I was trying to make indirectly is that since the dead hand is inevitable, it is normatively irrelevant. That is, no matter what institutional arrangements you have, or indeed what history you have, you will always have the dead hand controlling and limiting and shaping what you can do today, and therefore pointing that out has no significance in a normative sense. For example, just in the constitution-making setting that Larry was raising, suppose that the Constitution had adopted Jefferson's thought that every 20 years you start fresh. What could be a more momentous control by the dead hand of the past than telling us that every 20 years we have to stop everything else we're doing and rethink our institutions from scratch, even though we might be much more interested in pursuing other issues. It seems to me it would equally be an exercise of the dead hand if the Constitution said whenever a certain number of people want something put on the ballot for a national referendum, it has to be put on the ballot, and if 51% of the people vote for it, it changes the Constitution. Because that, again, controls what our agenda is today in a way that we might, in fact, find quite disagreeable. And therefore, it seems to me that pointing out that an institutional arrangement involves a dead hand is only in a sense to say that it is an institutional arrangement. The real question is, what kind of institutional arrangement do we want to have? And with originalism specifically, I think the question is not whether originalism represents the dead hand or whether constitutionalism does, but whether it is convenient for our society, to use what I think might be a Humean phrase, for us to proceed along those lines. Are these institutions or these variations on institutions desirable ones? But I think remarking on the presence of the dead hand doesn't advance the debate either as a justification for institutions or as a criticism.
Well, I just like to say two things, I think, in response to that. First, that the reason I think it's very difficult to separate out completely the normative questions from the dead hand questions depends what sort of question you think you're asking. Professor Moore suggested it's the question whether we agree with the original Constitution. I think I try to present it somewhat differently, whether the Constitution was a true, in some sense, close to a scientific account. It's very odd even to talk about is the atomic theory a dead hand on our operation today, for instance. Secondly, I think you might also look to human nature to understand a bit why the Constitution is, why you might want to have a written Constitution, because it's also in the nature of man sort of to deny human nature when it's in his interest to do so. While language has many advantages in terms of helping us have gains from trade, it also is a wonderful way of expressing falsehoods. And so that natural argument, I think, would underlie all the kind of prudential arguments that were made. If we have something that's working, it's because of the nature of man that we know we should stick with it, because we also understand the nature of his ability to, particularly in a democratic process where people don't pay much attention to it, to have leaders who lead people like Pied Pipers away from whatever truths that have been uncovered.
Hi, I'm Scott Gailey from the University of Chicago. And I was intrigued by Professor Sager's points regarding the transition from the Articles of Confederation to the Constitution, and then again the American Civil War. And I was wondering, to what extent is the extra constitutional right of revolution part of the dead hand?
Well, on the account that I was offering, we would have to distinguish between two different kinds of claims. One would be a claim that is, in essence, a legal claim, assignable to the Constitution directly. The other would be a claim sounding in political justice, something, in my view, above or behind the Constitution in some way, and accessible for us through the Constitution and constitutionalism. I think the right of revolution, or the right to change government in non-military ways, that in circumstances of breakdown, is really a claim about political justice and the circumstances of a democratic people residing together, and perhaps not even only a democratic people. And in that sense, this isn't an issue of the dead hand, except insofar it's about the circumstances in which claims of political justice would vindicate the rights of individuals to reject the dead hand of their constitutional authority. So I think the dead hand only comes in negatively in the right of revolution.
It does conjure up an amusing picture of a group of revolutionaries getting together and they really dislike the regime and they want to have a revolution. And then one says, well, now what's the tradition on revolutions around here?
Yeah, I actually had another amusing scenario in which a group of people get together and say, our society unfortunately is captive of a tradition of revolutions. And unless we can escape that tradition, the dead hand of our revolutionary past, we won't be able to move forward into a more prosperous and stable future.
I hate to think how that hand is held somehow.
Larry Alexander.
Excuse me, go ahead, sorry.
You want to recognize me, though?
I just wanted to make sure you said your name, and then it occurred to me that you had.
Actually, it was the name of someone else, but it has the same name as I.
It's an excellent name.
I wanted to actually press Michael on his response to Gary, where you appropriately separated out the question of authority from the normative attractiveness of whatever we're going to deem authoritative. And that's of course right. But then the question is, do you have any theory of authority that is different from a normative attractiveness, which of course itself gets rid of any theory of authority? And just, it seems to me the dead hand of the past problem that this panel is addressing is really just an instance, the more general problem of any practical authority that permeates all questions of law. And so you have a short 1-minute theory of legal authority, which would work both for contemporaneous legal authority and for the dead hand of the past.
You're making me feel guilty with emphasis on the word short, but here goes. The temptation is indeed to think that all law demands some adherence to the past. That's what a government of laws, not of men, is supposed to be about, right? So the question then is, why other laws? Why do they have practical authority? Well, think of morality, as you well know. This is really to everybody else. He knows this stuff totally. The difference between requests and promises. Don't you think the fact that a friend has made a request or that you have made a promise in response to be a bit now of the past that changes your moral obligations? And don't we think that the outputs of democratic legislatures called statutes have that same potential for change? It's because we have a good normative theories about requests, promises, and statutes that makes them morally relevant, no matter what their content, within limits, right? So the temptation is to take that familiar notion of authority about law in general and certain other things in morality and apply it to the Constitution. But that leads to this thing called the social contract theory of the Constitution, which would give you a reading of Article 5 quite different than Larry's. It would make it then a contract that binds us by our consent. Even though, remember, Thurgood Marshall said, weren't my people. Well, they weren't any of our people, right? We had no agency relationships, as we do to legislatures or to our own promises. So by negative argument, the answer is no. There's no theory of authority for the Constitution, anything like that for a statute. And then if you wanted a less short answer, I then go to the positive theory.
Okay.
Well, doesn't McGinnis have a theory of authority? I thought I heard it. Hardwired.
Right. I mean, I think my argument of authority is that the concept, and I don't, incidentally, I would think that my response is in actually a long tradition of American constitutional responses to this. Actually, if you go back to Story, he really responds to the Jeffersonian Republicans by arguing, we have a science of government. We've discovered these truths about government. I'm trying to suggest why I think Story's response is even more powerful today than it was then. And we really shouldn't be, it's not simply a question of agreement, it's a question of prediction. And there are strong reasons, therefore, to completely sort of dissolve this question about whether it is a dead hand of the past. That carries with it an implicit normative premise, which I think I rejected at the beginning of my paper.
Go ahead, sir.
Terry Barris. Does the provision of the requirement of public officials taking an oath to support the Constitution Is that of any significance in this debate? And does that in effect require them to put themselves, or maybe us as lawyers who take an oath, do we put ourselves under some additional restraint voluntarily as well? As far as how free we are to, in effect, interpret the Constitution, or have we agreed that there is a set authority, and an authority of set meaning that we've agreed to bind ourselves?
I think the oath is normatively relevant given its similarity to a promise. 2 points. One, the oath doesn't give you a systemic reason. It may give to each person who's taken the oath a personal reason strictly analogous to that given by a promise to now change their reasoning from what they would have done prior to the oath. And in that sense, it gives authority to whatever they gave an oath to support, the Constitution. But it doesn't give you a system-wide answer to Thurgood Marshall's question, which is, why do we require oaths of our officials to this old document that none of us were around to sign on to? The systemic question survives because it's a question about why have oaths if they have this effect on individual moral judgment. The second point is this: even at the level of an individual judge, you can take your oath of office the same way that Rose Bird took hers as Chief Justice of the California Supreme Court, which is, well, of course, it says you to uphold the Constitution and the law, and now I'm going to give you my theory of the Constitution and the law. That's not fixed in the oath, and each judge may take it upon herself, as Rose Bird did, to give her own theory. By her theory of law, that's what she was upholding.
I actually would say that the oath had no normative consequence, and I would say so for two reasons. One, because in terms of H.L.A. Hart's description of law, in our legal order, the Constitution does enjoy installed stature. I don't actually think it's the ultimate rule of recognition in H.L.A. Hart's terms, but it's getting close. And any public official would implicitly assume, as a matter of social and legal practice, the obligation to obey the relevant sources of law within the society. Secondly, I think there are independent normative reasons for all persons, and particularly public officials, to ally themselves with the Constitution. And I think those swamp anything that the oath is redundant to the first proposition and overwhelmed by the second. And I don't know, I'm not sure whether Michael and I differ. I know we differ about certain questions involving Rose Bird, including the propriety of impeachment. But I think not only can a judge take the oath the way Michael described her taking it, I don't think a judge or a public official can take the oath meaningfully in any other way. That's the only way one can take the oath to support and defend the Constitution, it seems to me, is to take it on one's best understanding of all of its entailments for a person in their legal position within the society.
Yeah, I was going to say the same thing in less intellectual terms. So it seems to me that when Michael Jordan decided to either play baseball or basketball, he didn't have to take an oath each time about which game he was playing, what set of rules. When he decided to play the one where you wear a glove, he was automatically accepting a different set of rules than when he plays the one that's played on a wooden court. And I think an oath to uphold the traditions and meaning of baseball would not add very much to the force of the rules as part of the game. And similarly, when you go into the government, you're kind of accepting the government game in some sense.
I believe Professor Steve Calabrese is next. The droit de seigneur.
I just wanted to to take issue somewhat with Professor Farber's analogy to architecture by suggesting a different analogy, which seems to me perhaps a bit closer, and that is perhaps the obligation of the present to follow past constitutional provisions, at least where they're, particularly where the words of the provisions are very clear to senators from every state, for example, is related to, for example, the desirability for present generations to honor the national debt or debts entered into on behalf of the nation by previous generations. We are continuing today to pay off a national debt that was entered into by our predecessors. Conceivably, some small portion of it still, for example, might be going to pay off the costs of defending us against Nazi aggression in World War II, certainly to defending us during the Cold War. We pay off those debts and perhaps other debts, the wisdom of the prior generation incurring them, with which we might disagree, in part because the present is empowered by the obligation to pay off debts. It enables us to be able to borrow against the future, for example, to defend the country if that should prove necessary. It might enable us to borrow against the future to improve vital infrastructure in ways that would lead to a better life for the future. And we can't be able to borrow against the future for those things unless we honor the debts incurred by the past. Similarly, a regime of constitutionalism where you have to honor the laws, the mega laws or constitutional laws entered into by prior generations, enables us to have the freedom to adopt new constitutional provisions for the future that we might think would structure society in some better way. That system of intergenerational borrowing and obligation, whether with money debts or with constitutional provisions, is empowering to various generations because it enables us to adopt provisions. For example, the First Amendment guarantee of freedom of speech or of the press, which would guarantee that if you write a book today, you won't be prosecuted for something in it based on its content 25 years from now, or if you invest a lot of resources or labor today to build a factory, it won't be seized for no reason without compensation 25 years from now. It seems to me that mega laws like constitutions are empowering, that the system of intergenerational obligation is empowering to present generations and is therefore normatively desirable for present generations, either with the national debt or with constitutional provisions. With national debts or with constitutional provisions, there is always a right of revolution or a right not to pay the debt in some extreme case, but we ordinarily insist that the case be fairly extreme because otherwise the destruction of the intergenerational system of obligation weakens and hurts present generations, irrespective of the content of the obligation previously incurred.
That's a different analogy, and so I don't know whether it's an argument against the analogy I was using or not. I think because it focuses really on the normative question rather than the descriptive question that I was primarily focusing on, I think it goes to the question of, given that institutions will always have some kind of dead hand effect, how do we decide when, in fact, we should rebel against the dead hand or try to change things, and when we should go along with it? What is the sort of I thought about doing a law and economics presentation on the optimal deadness of the hand, because it seems to me there is a kind of question of diminishing marginal returns at some point. An easier analogy might be the legal institution of wills, where there may be all kinds of reasons why we honor wills, but one of them is that those who are in the living generation would like to be in the position to make wills themselves and have them honored, and we have an attachment to this ongoing institution that then leads us to honor the wills of the past. And I think that's true, but it does not answer the question of what is the optimal law of wills and to what extent should the law of wills rely on testator's intent versus current social policy. And it seems to me that's a question that really can't be answered either by invoking the general concept of an obligation to the past or of invoking the idea of an ongoing institution of obligation of the past, because it leaves open the question, what is the optimum ongoing institution? To what extent should society's institutions empower testators, and in what ways? I think in some sense it is inevitable that current distributions of property will reflect the distributions that obtained in the past, no matter what kinds of institutional arrangements you have. So perhaps my architectural analogy holds to some extent. But when we're talking about institutional design, again, my point is, I think should be what what testamentary institutions or what constitutional institutions over time will be the most satisfactory for society. And I just think invoking the dead hand or respect for tradition as independent normative arguments one way or the other really doesn't add much to the analysis of that question.
I also think that arguments of that kind, although they explain the appeal of some durable commitments and institutions, are selective to circumstances of reliance and long-term projects. So that, for example, issues about free speech could be handled by side constraints like no ex post facto laws. And the obligation to obey promises when people have relied on them and so forth is explicable independently. These may be part of an important family and may account for much, but they're certainly not going to account for a stance of originalism towards the Constitution, and nor can they account for a broad stance of respect for the past, it seems to me. They are more selective than that.
Sir?
My name is Bob Steigman. I'm from Urbana, Illinois, one of the state appellate judges who has taken the constitutional oath, and I'm a little surprised to discover what all it meant that I didn't quite understand before. My question is about the term dead hand in the entire discussion. It seems to me that we're talking about this on a sort of time continuum. We're talking about the dead hand of 1789 from the perspective of 1995 and possibly the dead hand of 1867. But I'm wondering if anyone in the panel would want to address the subject of why ought this to be a dead hand in this context. Namely, there are at least 4 pending constitutional amendments right now. They're getting a lot of excitement: balanced budget, term limits, flag burning, permitting under the Bill of Rights, the Equal Rights Amendment just a short time ago. We're spending an awful lot of time and effort and discussion on this, and if 200 years from now we're going to have another panel discussion talking about this dead hand amendment, what's the point?
If I thought that the time horizons of the typical politician extended even 10 years into the future, let alone 200, I might have a different response to that question. I think that in fact, I think that's an interesting example of the problem of deciding on an optimal dead hand rule. That is, as the framer of a constitutional amendment, I think it's an interesting question. What rule of interpretation would you favor for the amendment over a very long period of time? It's not at all obvious to me that you would favor a rule that gave a great deal of weight to your specific understandings or the general understanding of the time. One might think that 200 years from now, people might know, for example, a great deal more about economics and then therefore have much better ideas about how to determine if a budget was or was not properly balanced. And that the ideas that we might have today might not be terribly relevant that far in the future from the point of view of the drafter today. That is, just as in drafting a trust over a long period of time, you might well want not to allow the trustees to make up the terms as they go along, but to allow them some discretion in restructuring the trust. And I think you might feel that way about constitutional interpretation as a drafter. I think it's actually, the law and economic analysis is kind of complex. It depends a little bit on what structure of preferences you're assuming that the legislature had when they adopted the law in terms of what would be their optimal interpretative strategy. But I think it's an interesting question. We do tend to think of these issues only from the point of view of people who are dealing with a constitution already or statute already in place. And I think that's a mistake because as today, we're always in the situation of having at least potentially constitutional changes.
I do think that people should be talking 200 years from now. I particularly want them to ask Steve Calabrese's question, right? They can say one of those folks in the 1990s were paying off World War II debts. On the other hand, they got something good for it. 200 years later, we're paying off their debts from the 1990s. Exactly what did we get for it other than them leading a better life than they otherwise could afford? But in general terms, I think they should ask the questions. And even if the answer ultimately, given the position from which they ask it, They're an appellate judge in Illinois. They're not going to say the Constitution has no authority for themselves, right? The amendments are going to be part of the law you're going to use, will nonetheless have a practical bite to the enthusiasm you bring, for example, to judicial review. Had a debate last week about judicial review. Now, in some countries, that's a live issue. For us, it's not. As a colleague of mine said, there's a case on that for us, right? But nonetheless, how you answer that question, even as a sitting judge today, makes a lot of difference to the enthusiasm you bring to that aspect of your job. If you don't really think it's justifiable, you might adopt one of the crabbed and cramped varieties of judicial review that doesn't overturn much.
Yes, my name is Bill Singos. I was intrigued and a little surprised in some sense by Professor McGinnis's comments. I say surprised in the following sense. I was surprised to see Darwinism, and particularly, I guess, the social variant of Darwinism, enlisted to support and buttress what could be broadly construed as the natural law school. In the following sense, it would seem to me that the legal and ethical positivists have that market pretty well cornered, in the sense of rather than what is the hardwiring, the ultimate authority, when you have a dispute, is it recourse to rational discussion? Would it be recourse to some sort of revealed truth, or would it be, in Holmes's words, the ultimate rationale or the ultima ratio, brute force, survival of the fittest? So in that sense, it would seem to me surprising for Holmes to see no disagreement with Pollock on the issue of social Darwinism and legal positivism on one side and natural law on the other, or for Hart to find that there was no differentiation or disagreement with Lon Fuller, or in fact to see Darwin himself enlisted in support of the natural law tradition of the Roman Church.
Well, I don't think, first of all, I want to disclaim completely any argument about the idea of social Darwinism. I think that's very different from what I've been discussing here. I've been discussing Darwinism as sort of an explanation for human behavior, and social Darwinism an explanation about what things ought to be. The connection between I think the natural law and the view of positive human behavior, which I think the Constitution concerns, does have some connection to utility. I mean, there has to be some idea that social structures have to be structured against the grain of man, and we have to try to figure out what that is. And insofar as the Constitution has done that, it has really given us a science of government and a guide that really simply doesn't change when our ideas about what we'd sort of simply like to do, because we always have to recur to the brute facts about how humanity is structured. Because we know, we look, for instance, at places, at other kinds of societies where they try some other regime, some sort of Marxist regime, and we have some pretty good prediction about what's going to happen in those kinds of cases. And the reason one recurs to human nature is to really make those predictions and have some sense of what is possible and what is not. And I think the Constitution gives a lot of play to democracy to decide such issues, or at least it did, such very hard issues as abortion, while trying to limit, through understanding human capacities, what's really should be up for grabs, or at least at any one time.
Sir, I believe you're next. You're the boss. Yes, sir.
Hi, my name's Doug Smith, and I'm a student here at Northwestern. I had a question for Professor Farber about his architectural analogy. There seems to be a big difference between the dean of a law school and the administrators deciding they're going to knock down a couple walls and the building engineer who only has the authority to maintain the structure, or for that matter, the students who don't have any authority in this area to decide they want to knock down a few walls. Analogously, it seems that in the constitutional context, there's a big difference between the people deciding that they want to change the Constitution and not be bound by the dead hand of the past, and judges doing the same thing. And I was wondering if you think that it makes any difference, in talking about the dead hand, in defining who has the authority to overthrow the dead hand.
Well, I mean, it seems to me there's a continuum. That is, there are major changes that are very expensive and that have to be made using very careful procedures and a lot of input from different people. And there are small changes like moving the furniture around in the library that clearly don't require that kind of process. And then there are a lot of things that are kind of in between. I mean, it seems to me as a practical matter, the answer is there are certain kinds of major structural changes that we definitely do not want the judges to be making. There are certain much more routine changes that we clearly do, and then there is a range in between where we may disagree among ourselves over whether this is the kind of change that ought to be made at this, through this particular mechanism, or ought to be made otherwise. And again, I think that goes partly to the question of how costly and difficult the change is. And partly to the question that I was raising before, what is the optimal set of mechanisms? How hard do you want to make it to make certain kinds of changes? I think the theory of our existing constitutional, I was going to say structure, I guess that's wrong, practice, that is the current functioning of the Supreme Court and other institutions, is that there are some mid-level adjustments that can be made by the courts. And some people think, no, the court should make only much smaller level adjustments. But I don't think either the architectural analogy or the dead hand analogy is going to tell you very much about that debate.
I just wanted to say that I'd far rather think that we were trapped in our buildings than trapped in our bodies. And that there's a big difference between Dan's example about architecture, which was intended to leave open a great deal of activity shaped by rather broad parameters and a great deal of choice, and a view of human nature, which, if taken seriously, argues for a great deal more being hardwired, not just in us, but in our government, than merely, say, federalism or separation of powers. Taken seriously, that view of human nature would resolve most of the deepest ideological disagreements we have about social policy on one side. And if that view of human nature... What?
Walk with it.
Right, exactly. If that view were justified as a means of explaining constitutional commitments to separation of powers and federalism, it would presumably justify strong constitutional commitments to particular economic regimes, to particular distributions of wealth and opportunity, to particular limitations on the taxation power. It's a claim that runs very, very deep and leaves very little elbow room for the democratic process or for disputes about these very critical questions about the plasticity of the human spirit.
Well, I think that if you go back to Federalist 10, I think it's hard to see Madison's view of Federalist 10 as seeing democracy as really performing a legitimating function in society rather than essentially a checking function to permit property rights to be exercised and to have great social benefits come from that. So I don't think it it suggests that we are going to have another way of bringing in all of these benefits. There are going to be still lots of decisions made by individuals as they individually pursue their interests, and so we're going to have a society will change in varieties of ways, and benefits will be received. It's just he's not depending on it being done collectively, and there are certain reasons that he gives for that. So I would I would say that my view is actually much closer to that of the framers. Now, I'm not saying, I do not want to be misread to be saying here that that environment never makes any difference. It often does. It's often very difficult to understand exactly how we can change the environment, to change the outputs of things. But the basic understanding that a private enterprise is going to bring greater benefits rather than relying on collective governance, which is simply going to turn into rent seeking, where people, where actually it's not going to help people who are poor, because they're not going to do necessarily very well in the government game either. I think this view is much closer to the framers, and what I'm trying to suggest is that it is a view that is on the return again, because I just cannot cannot really look at constitutional history in the past 70 years and look at the relationship between our understanding of human nature and human culture and not see a connection. And that's what I'm trying to point out here. I tried to point out, I said, in a somewhat unqualified way, trying to point up these polar opposites. But I think there is a deep connection between a view of the nature of man, or rather an abdication of the view that man has a nature, and for instance, the whole idea of the Great Society changes and some of the constitutional changes that came in their wake.
Let me mostly just keep Sandy from getting the floor for a few more minutes in order to keep him on his toes. Let me just, I thought it was something I was thinking when you said that about, in a sense, this was another variation of our perfect Constitution. And I think that's an important normative argument that is often downplayed. Because of the social contract tradition, we tend to think that the way the Constitution got created is terribly important for its authority. But much of its authority may come either from the advantage of having a stable institutional setting wherever it came from, or from having an institutional arrangement, a constitution that in fact is a very good one. And I think it's worth remembering that there are a number of leading industrial countries whose current constitutions were essentially imposed by force of arms after World War II, and therefore, in some sense, lack the kind of social contract legitimacy that we tend to look to. Nevertheless, as far as I can tell, people in those countries view those constitutions as quite legitimate, and in part because they are reasonably happy with the way they work. They think it's a pretty good constitution that they ended up with. I think that's an important source of normative authority that we sometimes tend to overlook.
Sandy, we have to be very brief, but...
Sandy Levinson. I'll direct my questions at Professor McGinnis. One of them picks up on Dan's last comment, that is there some message to be drawn from the fact that of the roughly 120, 150 constitutions in the world, not one of them has adopted the full American approach of all of the complicated, some would say Byzantine checks and balances. No country in the world has such a difficult amending process and the like. If one is going to defend the 1787 Constitution as a perfect constitution, and especially if one is giving quasi-Darwinist arguments for its perfection, then it does seem to me at least worthy of note that the evolutionary process since then and the market has certainly not spoken in favor of the specifics of the Constitution. Second question, and much more important, the previous occasion I participated in a Federalist conference, I was on a panel with Clarence Thomas, who gave a very interesting speech in which he called on his audience to take account of chattel slavery as a part of the 1787 Constitution. And it seems to me that if one is defending the 1787 Constitution as a perfect constitution, then one has to address the problem of chattel slavery. And is that particular property system part of its perfection? And was the demise of that particular property system via the 13th Amendment of uncertain provenance, does that count as one of the great losses, declines from perfection? Or would you say, no, of course, that's an absurd notion. Getting rid of slavery counts as making it more perfect, but if you say it's more perfect now, that logically entails that it was less perfect then, and that we, in fact, can engage in rational reflection on what the framers gave us and decide that at least some of what they gave us not only wasn't optimal, but was terrible and evil and indeed an agreement with hell and a covenant with death.
Well, to take the questions in reverse order, I don't think I think it's a mistake to say that I'm defending this as a perfect constitution. I thought I made that quite clear, but. And I think, indeed, it's also quite clear that the Constitution should have included a process of amendment to get rid of what I think is obviously the greatest, the deep and horrible beginning of the Constitution, which had slavery in it. It makes that amendment difficult because the amendment process difficult because there are a lot of other amendments that people could think up and perhaps persuade people unless there was a high standard for it. But I think I think that really also that kind of amendment process was still, I think, pursuing. If you look at the 1860s arguments, they're very much the kind of arguments that we're going to have a better republic if everyone is able to exercise his own self-interest through free contract. So I really think it is continuing in that tradition of the 1787 Constitution, and in some sense is bringing it closer to perfection, to use your terms. But I don't see a great break between the 14th Amendment and the Constitution of 1787. It's really getting rid of what I think was completely inconsistent with the view that I outlined here, that people can pursue their own natures. On the fact of other constitutions, well, first of all, of course, it is obviously not the case that evolution works in the last 150 years. Our natures have largely been constructed such as they are through millions of years in the past, and we're not evolving and changing our natures at any time. So it's not as if we're going to make our people better by having a better constitution. That's sort of ridiculous. But the argument I think we would have to take a look at is whether our constitution actually has been better in the welfare that it's given to our people than these countries without constitutions. And I'm not at all saying that you could not have other traditions which would be quasi-constitutional that would incorporate some of this correct understanding of human nature. And so those countries might do as well. I'm not saying that this is the only way of incorporating these kinds of insights into human nature. Other countries may have quite different ways of doing so. All I'm saying is that there is a key connection between our Constitution and truths about human nature that are eternal. And that's the reason that I think it is a mistake simply to think of the Constitution as a dead hand, as presenting this dichotomy between the past and the present. If our human nature is constant, there isn't a very strong dichotomy at all.
That's the last word. I wish we could continue, but better that we stay approximately on track. Steve, why doesn't your panel start at about 8 minutes after, and we'll have the break. Thank you for a remarkable panel.